This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. What happens when you entrust your money to a stockbroker only to find out that his or her interest in making commissions supersedes finding the best investment for you? What recourse do you have if you feel you've been a victim of stock fraud by your own broker? Today we're going to look at this issue with our guest Ted Eppenstein, an attorney who represents victims of stock fraud. We also have Ted Kresbach, who represents security firms accused of wrongdoing. Ted, tell us, you have a case, you feel that you've lost money in the stock market, and of course the first person you call is your broker. The broker did something wrong. What can you do? What is a case? What is not a case?
Well, what is not a case is easier to say than what is a case. What is not a case is if a person goes to the casino, spins the wheel, bets on black, it comes up red, you can't sue the casino. That's not
the type. That's an easy one.
That's an easy one, okay? The other cases, though, that we see run the gamut of all types of claims, from negligence, breach of fiduciary duty, breach of contract, fraud, misrepresentation, you name it, it's there. And it's in securities, it's in commodities. We see all kinds of instruments. We see stocks, bonds, commodities, foreign currencies. We have clients all over the world. They come to us from Belgium, they come to us from Switzerland, from Germany, from the West Coast, from the East Coast. It's rampant.
Now, Ted, you represent the security firms. What kind of cases? I assume there are tens of thousands, if not over 100,000 brokers nationwide. What kind of cases against these brokers that you see?
First of all, let me say right off the bat that we're talking about a very, very small percentage of brokers that are involved in these type of things.
Although I think last year there was over 6,000 arbitrations against NSAD.
Hundreds and hundreds of thousands of trades. You have to put it in perspective. The vast majority of brokers that I represent are good people, and the vast majority of brokers in the industry are good people.
Of course.
But there are always going to be a few bad apples. And what we see basically is everything, as Ted pointed out, from unauthorized trading claims to churning, which is when a broker takes over your account and buys and sells to generate commissions for himself rather than looking out for your interests. We see most of all cases of what they call unsuitability, which is a very gray area type of concept where you say basically, my broker recommended a stock to me that he should have known wasn't the right kind of stock for me. I'm a conservative investor. He recommended a speculative penny stock, that type of thing.
You don't even need that today. You don't even need a recommendation. There have been cases that have been won in arbitration and in court where the broker did not make a recommendation and the customer went in and committed what amounted to financial suicide, and the customer then later on went in and sued and won.
Are you giving me an instance where, say, a man or woman who had never traded commodities all of a sudden heard their uncle traded commodities, calls their broker and says, buy me sugar, and has lost? Is that what you're...
Well, I think it's well known in the industry, although they won't tell their clients this when they knock on the door, but only about 10% of the customers who manage or handle their own commodity accounts make money. 90% lose money. Okay? That is not well known among the investors. It is well known in the industry.
What about as far as stocks are concerned? If a broker gives you the wrong stock, you possibly have a claim against the broker?
Yes, if a broker makes a recommendation to you, which is unsuitable for you because of your financial background, your net worth, your occupation, if you're retired, something like that, you can have a claim against that broker for an unsuitable investment. Also, if the broker does not describe the risks of the investment that you're making to you, does not describe what it means to go on margin, for example, and just tells you the rosy side of the story, you can also go in and make a claim against the broker for that.
Now, Ted, I know many brokerage firms, before they even allow you to trade with them, make you sign all types of documents of disclaimers. What's your experience on that?
Well, generally, what most brokerage firms will do when you open an account is they have a new account form, and they'll use that to comply with what is known as the Know Your Customer rule. You have to find out the essential facts about your customer, their investment history, their sophistication, their finances. So there's a general form that they fill out with your name and your social security number, a bank reference, where you work, what your income and net worth is, where you may have traded stocks before, and that gives them a framework to know basically what you want, what you're looking for, and they usually will check off, do you want to speculate, do you want blue chips, do you want options, that type of thing. And that begins the discussion between the broker and the client, because it's a learning process.
That's the way it's supposed to happen, but Alan, we see many, many customers who come to us and say, you know, these papers were given to us, we were told it's red tape, sign it in blank, we'll fill it out later on, don't worry about it. And they're given a printed form or multiple forms, they sign it in blank, because after all, they're not worried about what the stockbroker is going to do to them someday. They're giving over sometimes their life savings, they're giving over their stocks, their bonds that they've accumulated over the years, they're opening up another account. It's like going to a bank, they're told, and they believe it. So they're not on guard, and they have to be, because these documents are often used against them in arbitration, because the stockbroker, in the cases that we see, which are the bad cases, okay, the stockbroker will take that blank form and will fill in the information that's most beneficial to him and the firm, so that the broker can trade as much as possible, so that the firm will have the ability, under its own rules and regulations, to leverage the account, to give as much margin as possible so that more trading can occur. We've seen fabrication of documents, of financial information. We've seen forged documents. It's a horrible situation. People really have to watch out.
How do you respond to that, Ted?
It's very simple. Again, what Ted is saying is he's talking about a very unusual circumstance. Obviously, we're talking here in arbitration about cases against people that may or may not have done something wrong. I've seen cases where there have been forged documents. I've seen plenty of cases where claimants have come in and said, that's not my signature, and experts have looked at the signature and said, absolutely, that's your signature. So what you have to realize, and I think the claimants' attorneys forget this from time to time, is just the fact that someone says I was ripped off doesn't mean it happened.
Ted, today there was the highest volume on the New York Stock Exchange in there. Hundreds of years history. I mean, people, the market is keep going up, up, up. I'm hearing that, in fact, my elevator operator gave me a tip just the other day to buy a particular technology stock. Are things getting out of hand? What's your opinion?
My opinion is that this is the time when you really have to be careful. For example, I go into this brokerage firm across the street from my office every day just to take a look at what's going on. And I've noticed, like they talk about during the crash of 1929, I see old ladies, I see retirees sitting there punching out stocks on the Quotron machine. I see people trading options, people that a year ago you never would have seen in there. The crowds are getting bigger. Everybody seems to be getting caught up in this. And that's why people like Ted Eppenstein are salivating, because they know when the market crashes, these people are going to be rushing to his office and they're going to be saying, this was not my idea. I was forced to do this. I was unsuitable. Give me my money back.
We see as many cases, if not more cases, in a rising market than in a market that tanks. I mean, yes, there were a great number of cases after the '87 crash, after the '89 situation, but we see more cases. We're getting more cases today. You just mentioned before at the top of the show there were 6,000 claims. Those are the claims that are filed at the NASD alone. There are more claims filed at the New York Stock Exchange, the American Arbitration Association, the National Futures Association. You can go to court in some matters. You can have reparations in some matters. It's huge.
Ted, what cases do you win and what cases do you lose?
Well, we've been very successful. All right. We settle or win over 90% of the cases we handle. That's above the industry average.
Do you work on a contingency?
Most of these are financial fraud cases. They're very complicated. They're very document intensive. We only handle the bigger cases. Most of our clients come to us and we're retained on an hourly basis. Sometimes there's some sort of blend with a contingency. But that's the type of case.
So I have to have money to retain you. Is that correct? If I lost all my money to his clients.
There are some situations where, as a matter of principle, we will take on a case. We've done a lot of pro bono work. We've appeared before Congress twice. We've testified to revise the securities laws, to revise the RICO statute. We've done a lot of work trying to get investors aware of the problems that are out there. Preventive medicine can actually be done in this area so that these clients don't come knocking on our door.
Okay. Ted, you agree with me, the mere fact that I've lost money in the stock market does not mean I have a claim against my broker.
True.
If I'm sitting out there watching this show, under what circumstances will I have a claim, or do I have a claim against the broker?
No, that's a very impossible question to answer in the few minutes we
Give me
have. I mean, what an individual really has to go to a professional to make that evaluation. Your viewer cannot do it on his or her own. For example, you may have a situation where someone is elderly, they give their money to a stockbroker, they think the stockbroker is well-meaning and just called the market wrong, and they lost money. And they feel they're responsible for it because they got documents which showed the trade. That doesn't mean that they're responsible for the recommendation, because the recommendation that's made has to be suitable for them. And if it's unsuitable, that individual can go after the broker for whatever loss there is, and more, because in arbitration, you're dealing with an equitable tribunal. Arbitrators are there. We ask them to make the customer whole. We ask them to give the customer the money back, to pay our attorney's fees, to pay the expert witnesses we had to put on the stand, and we also come in with a market-adjusted analysis in many cases. If the broker said to the customer, for example, I promise you you're going to make 15% on your money, we're going to make a claim for that 15%. Another example, if the customer was put into unsuitable investments, which we were talking about before, we have an expert come in and they will have a mock portfolio as what the customer should have been put into, and we will ask the arbitrators in an award to give us the difference between what happened and what should have happened.
In a court of law, there are cases that you can read as to what a court makes the determination, what is suitable and what is not suitable. In arbitration, do you have that decision-making process also, that you know what is suitable and not suitable by other arbitrators?
It's not the same type of precedent that you have in court where they publish decisions of the cases and that precedent binds you in the next case or binds the judge in the next case. Arbitration's a different process. You have people from the securities industry, people from the plaintiff's bar, people from the general public that sit as arbitrators, and they basically look at the facts of each particular case and do what they consider is justice. And just because a particular arbitrator in one case said, I'm going to look at it this way, it doesn't necessarily mean that another arbitrator is going to look at it the same way. Each case is very fact-specific to that case.
If you lose an arbitration, can you appeal it?
Generally, no. You have to show, there are some areas under the Federal Arbitration Act that you can go in on. For example, manifest disregard for the law. I've never seen a case won on that appeal. If the arbitrators, however, refuse to take evidence in or refuse to have a witness come in, and that witness is someone who is an important person, that may be a grounds to overturn an award. If there's corruption, if there's bribery, something like that. It's a very high standard, though.
But keep in mind, it's very rare to have appeals in arbitration. That's one of the great parts of the system, okay? Think about it logically. If you're a small investor and you've lost money in the market, maybe your hard-earned savings, you win an arbitration, the last thing in the world you want is for a brokerage firm to hire a big firm and appeal this for a couple of years. You want to get your money. And one of the joys of arbitration is its simplicity and the fact that you get an arbitrator, you sit down there, you tell your story, you get a decision, and you don't have to worry about spending more money to collect the money.
Ted, why do I have to go to arbitration as opposed to bringing them into court?
Well, that's because the industry imposed on the customer 10 years ago a contract, which is a contract of adhesion. And in the law, you know what it is because you're a lawyer.
That's a big word. What does adhesion mean?
It means you have to sign this, otherwise we won't do business with you. And unfortunately,
if you want to trade stock, you got to sign the agreement.
You got to sign it. And there's an arbitration clause there, a binding arbitration clause, which courts will enforce. Well, what does that mean? That means a customer cannot go to court with a claim for fraud. Now, customers don't know this and don't realize it when they have this printed form and they find the clause somewhere buried within it. However, I have to tell you that despite this arbitration clause, let's say there was no clause at all, customers could still go to arbitration because of the membership of the broker-dealer at the NASD or at the New York Stock Exchange.
We'll continue this discussion right after the break. We are watching Lawline. Stay with us.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals. All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives or doesn't together.
Excuse me. Do you wear your safety belt?
Why, no, I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about representing investors, victims of stock fraud. With us are Ted Kresbach, who represents security firms, and Ted Eppenstein, who represents the victims themselves. Ted, you wanted to say something right before the break?
Yeah, I forget what it was, but talking about victims, I know what I want to say. We tend to think of victims in terms of investors. I'd like, from my perspective, to talk about victims in terms of good, honest stockbrokers, and there are tons of them out there, the vast majority of them. We have a system nowadays where if a claimant files an arbitration against a good, honest stockbroker, a malicious lawsuit, a completely frivolous suit, taking a shot, just like you would at a casino, that goes on the broker's record permanently, and that broker is scarred and marred for life. And I
Oh
think
my
that,
God,
to me,
this is terrible.
I have to tell you, that bothers me a lot, because I see a lot of good people whose reputations are ruined by frivolous claims, and we see frivolous claims every day
I
of the
don't
week.
see, that is not the case. First of all, we don't file frivolous claims at our firm. I don't believe the majority of the people who do this kind of work do that. We investigate our claims. We make sure we have a good case. Otherwise, we won't take it.
If you're
we
winning
turn
90%
away.
of your cases, there's no doubt that you are doing your homework. But I have to tell you, you may be the exception. I see cases every day of the week where arbitrator or lawyers will file claims on behalf of a claimant and say this person was unsuitable, this person never was invested in the market in their life.
And those cases will lose. And those cases will lose. And there's no harm to the broker, because at the end, in the RE3 form that has to be filed, at the end of the arbitration, there'll be a statement.
That
customer loses.
Ted,
claim will be on their record the rest of their
It
life.
doesn't, but people read the whole record.
My viewers are always interested in money and costs. If I'm going to arbitration, how much does it cost them? I know that we have to pay your fee, and that's an hourly fee. Normally, what does that run?
Costs, it depends on the case. I mean, we have some cases where there are $15 million in out-of-pocket losses, $20 million in out-of-pocket losses.
But I assume that's not the typical.
Typical
The
cases are $100,000.
typical case is somewhere around the 100 to 150 in losses, sometimes a little bit less.
The legal fees, they must have
Now,
a range.
the legal fees for the smaller cases,
Right.
and I call them smaller
I
because
understand.
for some people, $25,000 is a huge amount to lose.
It's all their savings.
Okay,
to me, yes.
there are simplified procedures for those smaller claims, okay? So that people don't have to come to Ted Eppenstein or another law firm that specializes
Can they do it
in this
themselves?
area. They can do it themselves in a simplified case. They can do it themselves in a bigger case, but I would never recommend they do it themselves.
And I wouldn't recommend they do it themselves.
And how much are the arbitration fees?
In a simplified case, it's very little. It's very little. It's all done on paper. You just send in a letter. You advise the panel what your claim is. There'll be a public arbitrator selected. The respondent will put in the defense, and there'll be a decision.
And on the more expensive
Few
case?
$100.
All right.
In the more
it's
expensive
very
cases,
inexpensive.
you can run into hundreds of thousands of dollars easily.
But if I've lost $100,000,
Right. Well, you have to be cognizant.
spend $200,000.
Obviously not. You have to be cognizant as to what the claim is and how strong.
if I lose, do I have to pay their fees?
Sometimes.
Very
If you're a
unusual.
customer or a broker, I'm sorry.
From a customer?
Rare
It's
that
very
you would
rare.
ever have to pay a fee for this. Now,
And if I win,
I've seen,
if I
you
win, do I get paid my legal fees back from them?
I think the statistics that I last saw, 25 to 35% of the time, you get some portion of
That's not
your
bad.
attorney's fees. Now, you can also get punitive damages. That's a hot topic. As a matter of fact, that's one issue, maybe the most important issue, where brokers will try to appeal where there's an award of punitive damages. They'll come in with a claim that courts don't have, arbitrators don't have the authority to
In other
do
words,
that.
We have to keep this in perspective, Alan, because punitive damages are very rare in arbitration just as they are in court. You may get an award of punitive damage 1 to 2% of the time. So it's almost silly to talk about punitive damages in the context of the overall process.
I can appreciate that, but what do I have to show?
There have been hundreds of cases where punitive damages
What do I have
been
to show
awarded.
to get punitive damages against the brokerage firm?
Something
Up to the
outrageous.
it's up to the arbitrators. If you can move the panel, if you can reach them emotionally, if you can show them that what happened to this individual claimant, your client, was horrendous, should never
Outrageous.
happen again,
Reckless?
the only way to punish a big firm is through its pocketbook.
Yeah, but,
And the arbitrators have the ability to do
but
that.
these firms make hundreds of millions of dollars.
All the more reason why they should pay thousands, hundreds of thousands of dollars in punitive damages.
Let me just
In the
point out,
appropriate
this is-
case.
The securities industry is the most regulated industry of any industry in the country. A brokerage firm does not have to get a punitive damage award against to know that it's supposed to do the right thing, that it will do the right thing. It's subject to regulation by the New York Stock Exchange and/or the NASD, the Securities and Exchange Commission. Any of these
doesn't
people,
protect you
any
from
of these
fraud.
people have the authority
If
to
there's
find the
fraud
firm,
in your heart,
to discipline the
you're
firm,
gonna be
fire the
subject to a
brokers,
lawsuit
to
or
take
an
their license
arbitration.
for life. So if you're a stockbroker, you have to think long and hard before you defraud a client, because if you get caught, you're going to be out of the business.
Alan, the SEC and the other regulators are not in business to get customers their money back. They look for the huge frauds, the Michael Milkins, that type of situation they'll get involved in. They won't get involved in the cases that we bring for our
Ted,
individual clients. It
any
just
day-
doesn't
any
happen.
day of the
Even
week,
if the
you look in the
regulators are
newspaper.
investigating, it won't happen.
Ted, for a customer to retain your services, how materialistic, what size loss must they have sustained in order to make it a business decision?
For us,
Yeah.
I would say now it's about $500,000 and up in terms of out-of-pocket loss.
Okay. Otherwise, it just, at least to retain your firm.
We have, we're a big firm in this area in terms of personnel.
Right.
We have 5 attorneys, we have law students, we have secretaries. That's big for a boutique firm specializing in securities fraud for the claimant, all right? We are very selective, as Ted pointed out, in the cases that we take. We only take good cases, and we only take cases where there's a big number.
Ted, I assume that your clients want to settle these cases when they feel that there's some sort of thing that they did.
Without a doubt.
How often do you settle cases, even before it gets to arbitration?
I represent probably in the last year 10 different brokerage firms, from
Right.
small to some of the most well-known names you'd recognize. And they have one thing in common. If there's a bad case, they want to do the right thing. They want to pay the money, they want to settle it, and they want to move on. What happens a lot of times is you run into a plaintiff's attorney who is asking for an exorbitant amount of money. The client lost $100,000, and they won't settle for less than $500,000.
Because of the
Sometimes-
punitive aspects, you mean?
Because whatever they want to argue, some of those cases with really bad facts, the brokerage firms are almost forced to go to hearing on because they can't settle it for a reasonable amount. And I think that's where most of the punitive damage awards come in, cases that firms normally would try to settle.
Ted?
We don't see that. First of all, it was reported in the major newspapers in New York and the Wall Street Journal that we had the largest settlement on record at the New York Stock Exchange. Now, to get to that point, in any case, you're going to have to prove the case to the brokerage firm. And in order to because they have to be scared. They have to be scared that they're going to have a number
When
that's
they
thrown
see your
at them.
name, I'm sure they're very
Well,
concerned.
I would hope so. But in order to get to that point, you usually have to go in and try your case. And sometime before award, you're going to get your best settlement if you've proven your case. And so we've seen
During the arbitration process.
during the
itself.
arbitration process, we've had cases.
Every firm's got a different kind of reputation. I can tell you from 15 years experience, your firm has got a reputation of being a tough settle. Okay, you're always fighting for that last dollar, and that's to your credit. But I have to say, most cases settle. To answer your question, over half of cases that are filed settle. Of the half that go to arbitration, customers get an award in roughly 50% of the time.
What would be your advice to the investors out there?
My advice to investors out there is to remember that this is your money and nobody's going to protect it as well as you are. It's one thing to have a relationship with the stockbroker, but ultimately no one knows what you want better than you do. Stockbrokers are trying to do the right thing, but they're also looking for guidance from you. They don't know your investment objectives unless you clearly articulate what they are.
Yeah, but if all my friends are making money, I want to make money also.
Everybody's greedy. It's human nature. And in a market like this, people are jumping into the market. They're doing it because they want to make a quick buck. When they lose money, I guarantee you half of them are going to say, I was unsuitable. I never should have done this. My broker made me do it.
Ted,
It just doesn't happen that way. Not the way I see it.
what would be your advice to the investor out there?
Many. First of all, when you go in, advise your broker what your investment objectives are. Put it in writing, get him to acknowledge it, give it to the branch manager, meet the branch manager. Number two,
Most important, think about what
read all the papers that you're given to sign. Number three, sign nothing in blank. Number four, don't give discretion to your broker.
What is
That means
discretion?
don't let your broker act without your prior approval.
Trade your
Never.
account.
Right. Under any circumstances.
Always call me if you want to buy or sell a stock.
And reach me. You can always reach me. There's never going to be a situation where I'm not going to be available. And if I'm not going to be available, then here's the telephone number of my brother. Call him if it's so urgent.
Are those conversations taped by the brokerage firm as a matter
They
of course?
can. They usually are not.
Okay.
You know, the most important thing I could tell a potential client that's never been in the market before is you have to have realistic expectations. You know, the stories you're hearing from your friends about the killings they're making in their market may or may not be true, but I can assure you they're not hearing about the $100,000 or the $50,000 they lost. If you get in the market at any point in time, I don't care if it's a blue chip stock, a conservative stock, speculative stock, you have the opportunity to lose money.
Ted, you gave me statistics on commodities, on how many investors make money in commodities. Is there the same statistics for actually common stock?
No. Commodities are much more speculative. And the statistics I gave you actually came from a case that I tried within the last 10 days where the branch manager testified to that. So this is not something that the claimants are making up. This is the industry.
So right now, there's a tremendous feeling the stocks are going up a point, 2 points a day. You see technology stocks, $2.50 a day, $3 a day. Everybody wants to make money, but what's your advice to those people who now want to get into the market?
Know what you're investing in. Learn as much as you can. Don't trust your stockbroker. Don't consider your broker a financial consultant or an account executive. That's not what they are. These people are like used car salesmen. They're selling you used products when they're selling you securities, usually. It's a security that's been traded before. Treat them that way, okay? If you don't understand the statements that you're getting from the brokerage firm, go to someone who does. Go to your accountant. If your accountant can't understand it, then there's a problem. You must be aware, buyer beware in this area.
And another good piece of advice, too, there's a lot of firms out there. Deal with a reputable firm. Check out your broker. Ask questions. There are hundreds, maybe thousands of small firms with one or two people. You don't have to deal with their firms. Deal with a big, reputable firm that'll stand behind their broker.
Is there any books or something that my viewers can read to find out what stocks are suitable for them?
You know, there are plenty of books out there, but they're all written by investment advisors and stockbrokers and brokerage firms. Okay? You have to deal with someone who you trust, and then you have to check them out, and there are ways to check them out.
Ted Eppenstein, thank you very much for appearing on Lawline, and Ted Kresbach, thank you once again for appearing on Lawline. And as always, you have to watch your own money. This is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.